Good morning. Good morning. Good morning. Amazing law nerds. It's good to see you. So today we're going back to Massachusetts. Yesterday we took a brief detour to South Carolina. Next week we'll be in Utah. Don't worry. But yesterday, we took a brief detour to South Carolina. Today we're heading back up north. A lot has happened in Massachusetts. We have much to catch up on. And thank you for everyone who's already caught up and was not in the throes of like all of the lifing things. Thank you for no spoilers, because I have not seen the hearings that we are covering today. I have pulled some court dockets that I think are needed, and we are going to go through what happened in the hearing I thought we were going to be covering this week, which was the hearing that they set as a status hearing on Zoom. And then I thought we were just going to cover whatever filings there were because we knew there were going to be a bunch of motions to compel. Let's do the intro, then we'll do a quick road so far. Then we're going to do a timeline from where I thought we were going to be to where we've ended up, because I don't know. I don't know why there was an emergency hearing put on calendar. We're going to go through those docket items together. We're going to go to the emergency hearing, and then we are going to go to court in Massachusetts. So with that, law nerds, let's roll the intro. Technology is spicy. Thank you for no spoilers. We're going to go to the intro. Today's already todaying. It's great. It's Thursday. Did I say? No, I don't think I did. The earring's falling out. Perfect. It's Thursday. It's July 2nd. It's summer. It's hot. Everything is awesome. Everything is awesome. Let's go. Let's go, law nerds. Streaming is dynamic. It's going to be great. Hey there. I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. I know it's always hard to give an intro of what to expect when what I expect is, y'all, WTF is even happening. Hope always, it was over 100 degrees at my house yesterday. I don't know exactly what temperature it is today. It's hot. I don't know. It's only 92. It's the humidity, though, that the humidity is really what's going to get you. So, road so far. You guys know that I was traveling. I was getting to see Travis. Hadn't seen him in a month. Dr. B injured his back. Things have definitely taken my attention. Dr. B is improving today. And so that makes me very optimistic because we're not getting worse. We're getting better. So I'm real excited about that. And so when I say that I am behind, there is so much going on. We're going to get to a lot of it next week. We can't get to everything this week. And Team Baker is going to be off tomorrow in observance of 4th of July because Team Baker works so hard. And Team Baker is going to be off tomorrow. And I am not changing days off for the team because team has plans, and that would be very, very rude of me. So also, I want them to take time off because Team Baker works quite a lot. So we're taking time off tomorrow for the 4th. I will be sharing things in the app. I have stuff I wanted to share from traveling, and then with all of the caregiving, we were delayed. So I've got stuff I want to work on, but it's nice to have the ability to do that kind of in my own time. And then it's Tennessee. So there will be some fireworks because the fireworks here are insane. It's so good. So that's the plan. Next week, we will have a lot to get into. I will have a new podcast for you on Monday that's going to be an overview of some of the things we haven't gotten to this week. And then we're going to deep dive some of that next week because we have a whole bunch I want to deep dive because so much is happening today in Massachusetts. So I went to the Massachusetts docket and I was like, what is happening? I create my own docket that I have been automating a bit so that it automatically updates my calendars. And there have been so many dates on calendar the last couple of days because all of the courts are closed tomorrow. all of the courts are trying to get all of the things like moving before July just slogs into August and nothing happens. So a lot of these cases have had a pickup in the things that are going on. And then some cases just had a lot due on June, like 29th, 30th into yesterday, July 1st. Massachusetts is one of those dockets where I'm like, we knew stuff was coming. Karen Reed's team said that they were going to be filing additional motions to compel. The filing system in Massachusetts seems to have glitched. So there are some filings that you can read and there are some filings that just scanned weird and things are like overlapped and wild. So I don't know what's happening. Their system was down for maintenance and now things are just like, I don't even know. Things need to be reparsed by computers. Everything looks like a CAPTCHA. It's crazy. So there are multiple motions to compel going on. Tully is trying to like quash his deposition. We've still got the outstanding issue of the motion to compel Colin Albert, and there was supposed to be updated information from the defense on that we are still waiting for. Karen Reed has since filed a motion to compel Albert, McCabe's, Higgins, et al. They've opposed it. So much going on. So there was a hearing set that was supposed to be the last hearing until we got into the July 6th hearing that has now been moved to July 10th. So it was going to be the June 26th status conference, then the July 6th further hearing on the motion to compel Colin Albert, and then the other status conferences that are set later. The Karen Reed defamation case is back in court on July 14th, and Karen Reed suing everybody in federal court is also back in court July 14th. So I thought from June 26th, it would be kind of slow. I was incorrect because so much has been filed. And then they put an emergency hearing in person on calendar for yesterday. So we're going to start with the June 26th conference that was before they went to depositions that they had set a while back. We're going to start with that hearing, and then we're going to go to the documents that were filed since then. And then we will get to the July 1st hearing because I want to see what happens. And I haven't gone and seen what happens. So we're going to run up to how the fuck did we get to an emergency hearing on July 1st anyway. And that's the plan for today because we had been caught up to the June 26th hearing. For the most part, we had covered everything leading up to that. We knew that that was a status conference. So what is going to happen next? Well, that we are going to have to take a look and see. So did I bring oh no, I definitely didn't. Definitely didn't bring my notebook in. That's delightful for me. I'm going to have Griffin go grab it. Because today is todaying. So we're going to go to that June 26th status conference. Then we're going to look at some of the docket. Then we're going to go to that June 10th hearing. Sound like a plan? I think that sounds like a plan. Sounds like a plan to me. That June 26th status conference was via Zoom. Don't worry, we're going to fly to Massachusetts first because we haven't done that yet either. So let's fly to Massachusetts first, shall we? Shall we do that? I think we should. I think we're going to need it. I feel like today we're going to need it. Emergency in-person hearings are such an odd thing. So I'm real curious. I'm real curious. What is so emergent? Let's fly. Let's go to Massachusetts. All right. We're going back in time. We're going back in time to June 26th for this hearing. It was a Zoom hearing. They had set it at 9:45 in the morning. Remember, they were supposed to be doing depositions that day, and they had set it for before the depositions so that everybody could get there. So let's go to that hearing now from June 26th status conference. And we've got our hearing ready to roll. We did not live stream this. I don't know if anybody did.
Good morning, counsel. Just want to make sure
got
everybody
the
can hear
Zoom
me.
for you.
We can hear you, Kelsey.
Great, thank you. Are we expecting any other attorney to appear this morning?
Not for the plaintiffs.
Not for Mr. Reed either.
Not for Waterfall, Ms. Clerk.
Great, thank you so much. The judge will be right out.
We're back to Brady Bunch squares.
Good morning, Your Honor. May I proceed?
Please.
Good morning, everyone. Today is Friday, June 26, 2026. This is the Civil D session at Plymouth Superior Court before the Honorable Justice Mark Gilday. Your Honor, the matter before the court is Civil Action 2483-CV00692. Paul O'Keefe, individually and personal representative of the estate of John Joseph O'Keefe III et al. Versus C&C Hospitality LLC, doing business as C&F McCarthy's et al. Your Honor, for the plaintiffs, we have Attorney Daniel Buck present. For C&F McCarthy's, we have Attorney Kristen St. George. For Waterfall, we have Attorney John Dealey. And for Defendant Reed, we have Attorney Damon Seligson and Attorney Aaron Rosenberg, all present by Zoom, Your Honor.
Morning, counsel.
Morning, Your Honor.
So,
Morning, Your Honor.
do you have Mr. McCabe's deposition?
It's a minimal group this morning. We don't have nearly as many attorneys as we normally do. Yeah, it is a minimal group. So that might actually be easier.
Later this morning?
No, Your Honor.
Well, I guess now that I've seen the motions to compel, I'm not surprised that they did not have Matt McCabe's deposition. It was supposed to be on this day.
Seligson and Attorney Aaron Rosenberg, all present by Zoom, Your Honor.
Morning, counsel.
Morning, Your Honor.
So,
Morning, Your Honor.
do you have Mr. McCabe's deposition later this morning?
No, Your Honor. This is Attorney Rosenberg for Ms. Reed. That's the subject of the pending motion to compel that's going to be filed imminently, not the one you already have.
Right.
We had, just to update you, the last 2 days, Ms. Reed sat for a full day of deposition noticed by the plaintiffs.
Attorney Rosenberg, you're going to have to get closer to your
Sorry about that.
mic.
I mean,
I said,
well, not that close. Let's not overdo it.
I could hear Rosenberg just fine, but the court isn't using headphones. So I get why the court's just like, I can't hear you, but fine. Okay.
how's this?
Go
Better?
ahead.
Rosenberg, I appreciate that you still have a sense of humor with this man. Because there are days when the judge is so spicy, and then there are days where he's just like, we're all just friends here. And then there's days where he's just like yelling at everybody. I'm glad Rosenberg still has a sense of humor. Here, we're gonna join the Zoom call. How about that? Let's do that. Should we do that? Emily, are you distracted by your own technology? I mean, I'm delighted by the fact that I can. So why not? It's like that episode of The Office where they're all watching the screensaver bounce around and waiting for it to line up to the corner directly. I feel like that's what we needed to do.
So I was saying earlier this week, Miss Reed sat for a full day of deposition noticed by the plaintiffs. Yesterday, we had the deposition of Michael Proctor pursuant to your order on the motion for a protective order. Mr. Proctor appeared. The deposition began about 2.5 hours late at his request. But we
Tell me Proctor's running on EDB time. What do you mean? They start these at 10. We started 2 hours late on his request. Okay.
We did begin at roughly 12:30 and ended at 5 o'clock again at his request.
That's a short day.
But we were able to get started. That's from my end, the most recent update.
So you're not done with Proctor's depo.
What other depositions have taken place?
Your Honor, Attorney Buck on behalf of the plaintiffs. The plaintiffs also took testimony of Caitlin Boudreau, Miss Reed's sister-in-law, on the 17th of June. That went forward as scheduled.
And what, if anything, did you discover at that deposition from Karen Reed's sister-in-law, who wasn't there? Hey, Griff. Thank you, buddy. Do you want to say hi to the law nerds? We're live. If you want to say hi, you can. If you don't want to say hi, you don't have to.
Hello.
Oh, you do want to say hi today. Thank you, darling. I appreciate it. How are you?
Good.
Oh, don't lean back too much. The whole chair will go back.
Okay.
Are you going to say bye?
Oh, so I gotta say goodbye to people on the internet?
You don't have to.
Mom, I understand that's how you make a living.
Yes. You just want to sass at me from off camera.
I'm just over here walking away. I try to interrupt your stream and you're instigating.
I'm instigating. Hey, G, do you mind taking this for me? Thanks, buddy. I appreciate you. Thanks, darling. Bye, buddy. Thank you. It's a 10 out of 10. Oh, I haven't told him about the skill issue discussion yesterday. I'm gonna have to tell him about that. But yes, he grabbed me my notebook. I know all of you are like, he's so grown. I know. He's so grown. His hair has gone completely curly. It's a delight. His voice has changed. There's times when people call and they're like, wait a sec, is that G? Is that T? I'm like, I know. It's been a minute. He's just such a 14-year-old. I know. He's tall and he keeps growing. We're having the every time he wakes up, I'm like, shit, you're taller. You're taller than you were yesterday. Your pants aren't gonna fit. Okay. We're there. He's gotten so big. He is our bruh soundbite. That's Griff.
Bruh.
That's Griff a couple years ago. Right. Maybe we'll have to do a skill issue one. All right. Let's go back to court. I'm glad we got to say hi to G. G's definitely not done growing. Yeah. All right. Let's go back to court. Because he's like, going back to court. Cheers, everybody. Thanks for getting to say hello to G. I'm glad he popped in. I'm glad he pops in when he feels that he wants to, which is fun. All right, let's go.
I departed the deposition early to appear in front of your honor, but I believe it concludes.
Buck is talking about the deposition of Karen Reed's sister-in-law. So.
Your Honor, Attorney Buck, on behalf of the plaintiffs also took testimony of Caitlin Boudreau, Miss Reed's sister-in-law, on the 17th of June. That went forward as scheduled. I departed the deposition early to appear in front of your honor, but I believe it concluded. I can confirm Attorney Rosenberg accurately stated that we took testimony from Miss Reed on Wednesday of this week. We adjourned by agreement at the end of the deposition, and will work on securing a second date to continue that testimony in the near future.
Any other depositions?
No, Your Honor, I think the other ones that you were aware of from our end are all subject to motions to compel, including.
Oh boy. So all of the other depots, he says, are subject to motions to compel. And we have a new motion to compel that we have not covered. And it is for both the Alberts, both the McCabe's and Higgins. And then there's a pending one for Colin Albert. And then Tully is trying to quash his subpoena. So Tully, both, I hit my glasses and took them with me. Tully, both McCabe's, that's what I get for being dramatic. Tully, both McCabe's, both Alberts, Colin Albert, and Higgins. 7 depositions, 7 that are all subject to motions. Lisa Love in the chat said, a motion to compel. What does that mean exactly? I'm going to try to tone down my sass, but essentially a motion to compel is, Your Honor, they need to do this. They refuse to do it. Make them do it. And then the other side says, nuh-uh, Your Honor. Nuh-uh. I'm not touching you. I'm not touching you. Uh-huh. Nuh-uh. Yuh-huh. Your Honor. Make them show up for their deposition. It's that. It's, Mom, make them stop. So the motions to compel depend on the thing. Compel them to turn over discovery, answer interrogatories, appear for deposition, all the things.
The Colin Albert and Brian Tully, which is the motion I had flagged for Your Honor at our last appearance in person, which is now filed and docketed.
Since our last status, Ms. Reed's counsel did take testimony from Allie McCabe.
Correct.
Okay.
Thank you, Mr. Buck.
So one thing got done. Mr. Buck's like, don't tell this judge we've gotten no depots done. We've done two. Look, we've done two. We've done part of Proctor's, part of Reed's sister-in-law, and Allie McCabe. We've done look at us. Rosenberg's like, great. Yeah,
Okay.
we've
So-
gotten so much done.
Attorney Daly, what depositions do you have on the list here?
Probably not.
Your Honor, we have Michael Camerano and Caitlin Albert, who are patrons of the bar. We also have a forensic scientist from the state police, Nicholas Roberts, on our list.
That's for the
That's on
bar.
July 10th?
Yes, Your Honor.
Remember, the court also asked them for a list of the depositions. So the court has a list, presumably in front of him, because it looks like the court is looking at the list they gave him. So they have the list, and now the court is looking at the list and asking them, what else do we have? So Daly represents, I believe, CF McCarthy's, which is why Michael Camerano would be on his list, because Michael Camerano was at CF McCarthy's, but not at the Waterfall. St. George represents Waterfall.
Although that may get moved, Your Honor, but yes, it's on July 10th presently.
Okay, and on behalf of your client, Attorney St. George?
Good morning, Your Honor. I understand that representatives from my clients are going forward later this month. And I do not know what other depositions are going forward later. That's the only ones I'm aware of at the moment.
Your Honor, if I could step in here, we've been kind of coordinating depositions with CF McCarthy's. There are two additional patrons who are at the Waterfall, Karina and Nicholas Kolakithis. Those are
Leave the Kolakithises alone. The poor Kolakithises are going to be like, look, we've testified at a murder trial. Karina Kolakithis testified at the second trial and then are going to have to be deposed. For those of you that I agree with, what do you even need them for anyway? Here's why the bars would want them. Let's talk about why the bars would want them. If I am the bars are being sued essentially for over-serving. And both Kolakithises said that they interacted with Karen Reed at the Waterfall and did not observe her to be noticeably drunk. I would want the Kolakithises if I am the bar owners, because if you're the bar owners, you're trying to share that the bartender did not perceive Karen Reed to be intoxicated. The friends that know her did not perceive her to be intoxicated. So she was not overserved by the bar. It's not on the bars because the bars are also being sued. Because the bars are also being sued. So I understand why they might want the Kolakithises. However, do y'all remember the testimony from Karina Kolakithis from trial 1, where she's like, I had a really long day. It was going to start snowing. I got home, took off my bra, was ready to stay home. My husband wanted me to meet him for dinner with all the basketball parents. And then my kids are like, you never do anything. You never go out. Just go eat with dad. And she was like, fine. That was in 2021. They're going to depose her in 2026. And she testified at 2 trials. I think she is so valid with the, see? All I wanted to do was stay home. So valid. So valid. Itizuka in the chat said, who is suing the bars? In the wrongful death case, the O'Keefe plaintiffs, which are a variety of plaintiffs, but the O'Keefe plaintiffs, including the estate, are suing Karen Reed for wrongful death and also suing the bars for wrongful death, which is essentially an overserved argument as to the bars. So both bars are being sued. So the O'Keefes are suing Karen Reed and CF McCarthy's and the Waterfall.
They're presently scheduled for July 29th. They had to get moved from the 15th at the request of the O'Keefes. They could not make it on July 15th, but we're expecting it to go forward on July 29th.
Okay. So the O'Keefes is July 29th.
Okay, sounds like we're trying, but we're not getting very far. So I guess,
Yeah, Your Honor. They're all subjects to motion to compel.
a lot's going to be determined through the motions to compel.
Uh-huh.
And there was one filed yesterday, and when are the other ones going to be filed, Attorney Rosenberg?
By Monday at the latest. We now have the opposition. If we can get them in today, we will, but I'm not sure because we've had 2 depositions all day the last couple of days. But we will get them to you by Monday at the latest. And that's only one remaining. It just relates to a number of defendants.
Okay, I guess I'll get them when I get them.
The plaintiff's motions will be circulated and filed early next week as well, Your Honor.
And what are those motions?
That would be the motion to compel Aidan Kearney and the plaintiff's motion to compel further answers of interrogatories from Ms. Reed.
Okay, and has the motion relative to Mr. Kearney been sent out?
Correct. We have good service on a subpoena. The motion has gone out. We have not received a response to the subpoena nor the motion to
They
date.
filed it without a response.
And when's the 9/8 deadline over?
I believe it just passed.
Yeah, they filed it without an answer.
Okay. So you'll have that filed next week?
Correct.
All right. So we already have a couple dates scheduled, I know, in this case and in the Barnstable case. But let's pick another status date.
The Barnstable case is the defamation case with the Alberts, McCabe's, and Higgins.
A few weeks out. How about, there's no depositions on the 13th, are there?
Your Honor, this is Damon Seligson for Defendant Reed. There was a 30B6 deposition of the town of Canton, originally noticed for the 2nd of July, that is going to be moved to the 13th at the request of the town. So that date, we will have a deposition.
Your Honor, can I suggest some dates later in July?
Go right ahead.
Attorney Seligson and I had discussed needing to reschedule a deposition that had been noticed for the 27th. So I believe that's open right now. And I don't see anything on the 31st. I believe those
The
are 2
discovery
options, but
cutoff
I'll defer to counsel.
Is August.
Yeah. Truthfully, I'd rather have it sooner because we're getting close to the end at the end of July. So how about the week of the 13th? Is there any time to have another status so you can keep me updated as to the progress of discovery?
I believe there are depositions every day that week.
So do it at 9:45.
Okay, but we could do it 9:45 like we're doing now, right? So someone pick a proposed date that week. How about the 16th?
I was going to suggest the 16th, Your Honor.
Okay, we think alike, Attorney Daly. That's good. So, anyone else want to offer anything else?
Your Honor, this is Attorney Rosenberg again. Just briefly, I want to make clear that the Brian Tully motion to quash relates to a deposition that's fully noticed and subpoenaed as of now on July 8th. So I just want to give you those specific dates because that'll be before our next status.
Okay.
Thank you.
All right.
All
Thank
right.
you, everyone.
Thank you. Have a nice day.
Thank you, Your Honor.
All right. That's
Thank
the
you. Also, the
end
matter
of
continues
that
to July
hearing.
16, 2026 at 9:45 a.m. for status and July 10th at 2 p.m. for the motion to compel. Thank you.
Thank you.
Thank you.
Thank
All
you.
right. So that's the end of the June 26th hearing. And with that hearing, we heard just a very few things. One, most things are now subject to a motion to compel, either from the Reed side or from the plaintiffs. The plaintiffs have motions to compel out for Aiden Carney and for further answers to interrogatories, which are sworn question and answers. So, hey, question, and then you have to give a sworn answer. So they've got, the plaintiffs have those two motions out. With regard to the Aiden Carney, when the court was asking when did the 9A deadline pass, that's because Massachusetts has this process of motion filing that we've talked about in the past, where a party serves a motion on the opposing party, then the opposing party answers or opposes that motion, then there's a reply, and then all of those, motion, opposition, reply, those go to the judge together. But if the 9A period passes from, hey, I serve this motion on you, you have this window of time to oppose the motion. If it's not opposed, then the motion gets filed with the court without that answer from the other side, without that opposition. So the motion to compel with regard to Aiden Carney was filed after the 9A period closed. And so it was filed as just the motion, no opposition, no reply, because if there's no opposition, there's nothing to reply to. So just a motion to compel. Then we have the plaintiff's motion to compel further answers to interrogatories to Karen Reed. But we also now have Reed's motion to compel answers and depositions from McCabe's, Albert's, Higgins. And then we have the Tully group of motions where Tully is trying to quash subpoena for his deposition and answers, and they've opposed, etc. So it seems that basically everything of substance in this case is left to motion work. And we are going to take a look at briefly some of that motion work before we get to the emergency hearing. This was a status hearing. The court has been very much like, I want to get in everybody's business. What are we doing? Are things moving along? But then it seems to me when things are not moving along, the judge is hesitant to actually push them along. He just gets into hearings and is like, okay, well, we're going to need another hearing and we're going to need more information. And so things are not actually moving along. So with that, let's take a look at a few of these filings so we have some kind of an idea about how, well, I hope we have an idea about how we ended up in court yesterday, because it's got to be in these filings somewhere, because I grabbed filings. So it's got to be in these filings somewhere. We have, before we get there, because this same day that they were in court, June 26th, that was last Friday, the court filed an order answering making an order on the Colin Albert motion to compel. So we're going to take a look at the court's order. I said that super awkwardly, but we're going to take a look at the court's order with regard to Karen Reed's motion to compel the deposition of Colin Albert. We saw the court talk about it in multiple times in hearings, and I'm surprised actually that there was an order, because I thought that the court was waiting for more information from the defense, but it seems that the court was just like, we're going to order. So this was from June 26th, Friday, on this order. We're going to take a look at that right now. I should swoop. We haven't swooped in a minute. We should swoop. I feel like we're going to need it. Order relative to motion to compel Colin Albert to attend deposition and produce documents. 1. The motion to compel Colin Albert to attend a deposition is denied without prejudice. Subject to receipt of further information as to availability from his counsel. What are we doing? Like, what are we doing? What are we doing? We go to hearings. We go to hearings. You yell at everybody. You tell everybody that the subpoena is still operable and you've got to make your client available for a deposition. And then we get to the very end of the thing and you're like, well, we need more information. So just more delay then. The motion to compel Colin Albert to produce responsive documents is allowed as follows. Mr. Albert shall produce responsive documents communications for the period of January 28th, 2022 through June 18th, 2025. Oh, that's a longer period than I anticipated. Or represent through counsel that none exist. To or from Karen Reed, John O'Keefe, Michael Proctor, Courtney Elberg, Carrie Roberts, Chris Albert, Julie Albert, Brian Higgins, Brian Albert, Nicole Albert, Matt McCabe, Jen McCabe, Allie McCabe, Brian Albert, or Yuri Buchanan, which relate to the circumstances of the death of John O'Keefe, any law enforcement investigation of Mr. O'Keefe's death, and the plan alleged by Miss Reed of Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins to exonerate themselves and implicate Miss Reed in the death of Mr. O'Keefe. That's annoyingly narrow. And this is what we were talking about when the attorneys were fighting over what the documents would be, is how are they going to parse what is required to be turned over? And we talked about this quite a lot. Hey, what would you argue if you're the side not wanting to turn things over? What would you argue a communication about the circumstances of the death of John O'Keefe is? Would you argue that communications about who picked you up or when were about the circumstances of John O'Keefe and his death? You would argue that it's not. So this is narrow in the way that Colin Albert's attorney was arguing for. They got more of what they wanted, not all, because it's broader in time than what Colin Albert's lawyer asked for. But I don't think that matters because it's narrow in scope. It's not quite as narrow in scope as they had hoped for, but this is more in line with what Colin Albert's attorneys were asking for than in line with what Karen Reed's attorneys were asking for. So it is, when you're looking at the compromise that the court struck, that compromise is much further into what Colin Albert's lawyers asked for than it is towards what Karen Reed's attorneys asked for. It is a very much more narrowed scope of depositions, or not depositions, of responsive documents. So these are the responsive documents. I also think, as I argue that this is too narrow, what both sides are going to just argue more about what the plan alleged by Miss Reed even includes. Because I think that that language still leaves a lot of room for lawyers to argue. Do I think that this order means that we're done arguing about the motion to compel Colin Albert? No, I don't. Because they're still going to argue over what item 3 means. And there is going to be argument over, okay, well, this motion is denied without prejudice, so they have to go through a whole new month of a motion period. This is going to continue to be a mess. So this is now kicking the can further down the road to somebody else's problem later. Well, it's going to be this judge's problem later, but this is just continuing to kick the can down the road. So it's the biggest frustration for me is that I don't think that the judge is solving the problems before him. I think even this order just creates more problems. And I find that very frustrating. I can get on board with, hey, I don't agree with your ruling, but you ruled, you're the judge, whatever. This is just continuing to make problems. Fantastic. So let's take a look at what happened next. So that was the order on Friday. And then on June 29th, there were some other motions that happened between that. But on June 29th, we got another order from the court. And this order is related to the emergency hearing that we're going to cover. All right. I'm just making a note. Let's take a look at this order. This was filed June 29th from the court. Order relative to order of impoundment endorsement on paper number 112. We'll take a look at docket 112 in a minute. Well, spoilers. We'll take a look at the docket showing that 112 is impounded, but spoilers. I have been advised of information that allows for a reasonable inference of a violation of an order of impoundment issued by me. It is hereby ordered that 1. Each plaintiff and defendant and each counsel with notice of appearance in this matter. Oh, that's a lot of people. That's a lot of people. That's a lot of people. Because so many attorneys have notice of appearance on this case so that they can appear and stand in for the different hearings. But it's notice of appearance as of June 8th. Shall file with the clerk on or before 4:30 p.m. on Tuesday, June 30th. So the court gave them like less than a day. A certification under the pains and penalties of perjury as to all facts known to them, as to any dissemination to anyone other than parties and counsel in this matter of any of the contents of any of the contents of the material impounded by order issued June 8th, 2026, order of impoundment. Why is this sentence doing all of that? Have a number of you in chat are like, wait, this is from the court? Yes. Each plaintiff, so each party and defendant, and each counsel with notice of appearance in this matter as of June 8th, 2026, shall file with the clerk on or before 4:30 p.m. on Tuesday, June 30th, 2026, a certification under the pains and penalties of perjury as to all facts known to them, as to any dissemination to anyone other than parties and counsel in this matter of any of the contents of the impounded, the material impounded by order issued on June 8th, 2026, order of impoundment. Okay. So the court has concerns. Chat, no spoilers, please. We haven't gotten to the hearing yet. And I've had too many tech issues today to be patient. So I'll just yeet. So thank you, chat. Any in-person hearing is scheduled. An in-person hearing is scheduled for Wednesday, July 1st at 3 p.m. So he posts this on June 29th and is like, y'all are going to be here in person on Wednesday. All counsel with a notice of appearance shall attend. That's so many lawyers. All further attempts to take discovery from the party whose information was the subject of the order of impoundment is precluded pending further actions of the court. Oh, shit. Oh, the court's big mad. That's a big mad, judge. That is big mad. That is big mad. It is so many attorneys. Also, it's such a confusingly worded everything. I'm going to pull up the docket so we can take a look at it together. Because I want to see what the court is concerned about with docket 112. But docket 112 has been impounded. I don't have docket 112 in my research. There's sometimes things become a matter of the public docket and then get impounded. This was not one of those things. So we're going to take a look real quick. Except the CAPTCHA's fighting with me. We're just going to take a look real quick because it's impounded. And share. Also, chat, I know it's hard. I know it's hard for all of you that already watched this hearing. I know it is. Thank you. All right. Let's pull that up together because it timed me out. Even though I was ready, it timed me out. That sentence, man. All right. I was just waiting for the docket to pull up. This case takes a minute because it can be a little picky. All right. We're going to just take a look at the docket real quick together so I can show you guys what the court is talking about in this docketing. I'm going to try to make this a little bit smaller so you can see the docket numbers and the dates. We'll see if that works. Yay! Look, chat, we made it. We got it. We got the dates and the docket numbers. You'll notice that the docket numbers do not always follow it in order. I'll crash out about it another day. We don't have time. So we're going to docket 112. We looked together a few streams ago at docket 111, which I think subsequently got yoinked, but had been up. Docket 112 is right here. You can see that there's nothing there. It's impounded. Other interested party, Michael Proctor's motion to impound affidavits and supporting material. This is the day that the court was doing hearings all day and was like, hey, what's going on with Michael Proctor going to his deposition or not going to his deposition? And then they had to file stuff by like Sunday because Proctor filed his motion on Friday. And then they came into the hearing in the morning. And then the court was like, go back and get me more information. And then they came back in the afternoon and the court was like, well, we're impounding that information. And then we're talking about it, though, on the record that it was doctor's notes and stuff like that. So we're impounding it and then we're not and then we're talking about it. But it was all of the Proctor delay of depo. So the court's endorsement on the motion is on the public docket. So this is the endorsement. This is docket 112. This is not public. This is the endorsement on docket 112 that we're looking at now. Endorsement on motion to impound affidavits and supporting materials, number 112, other action taken. After hearing and having balanced the rights of the parties and the non-party deponent based on the particular facts of this case and taking into account all relevant factors, including but not limited to the nature of the parties and the controversy, the type of information and the privacy interest involved, the extent of the community interest, the reason for the request, I find good cause to impound and so order the impoundment of, for a period of 30 years? For a period of 30 years? I thought that was going to say, okay. The affidavits attached to this motion. I recognize the fear of unjustified adverse publicity is not sufficient to constitute good cause. And then the court lists the case. However, a legitimate expectation of privacy ordinarily is sufficient to constitute good cause and lists a case. 30 years is what this impoundment says. So that's the endorsement on the impoundment. But if you go back and listen to those hearings, they talked about it at length, not in tremendous detail, but we knew it was doctor's notes. We knew it was related to mental health. We knew that it was related to Proctor. We knew he wanted to delay his depo. We knew that the court had questions about the affidavit that was submitted and whether the person submitting the affidavit had the credentials to even submit the affidavit. So we knew that this was medically related because the court did all that on the record and the attorneys talked about it multiple times that day on the record. This is that entire day of like hearing, then hearing again that day. So that is docket 112. Docket 111 has since been stricken, but we went through Docket 111 when it was public. So Docket 111 had been on the public docket and then was pulled off the public docket. Let me just go back and look at that real quick. We covered it before it was yeeted. So, there was no order of impoundment when we looked at it, and then it was pulled later. I just don't remember exactly what was in Docket 111, but it was related to all of this. So, that's right. Docket 111 was the letter from Rosenberg that was like, Your Honor, counsel wanted me to clear up the issue with regard to what I said during the hearing about Colin Albert not being at his deposition. That's what 111 was. I had forgotten about that. So, not related to 112. So 112 was the order to seal Proctor's presumably medical information. I don't know if they're medical records. I don't know if it's just a declaration from a treatment provider, but medically related stuff. We talked about this quite a lot the day of this hearing because there had already been a lot of speculation, enough that even though I am not spending a lot of time on socials, I had gotten a bunch of emails and we had seen comments in chat before this about, did you hear Michael Proctor? We had seen a lot of that. None of it was substantiated. But we had seen a lot of speculation before this hearing date about Proctor. And I had speculated about whether or not Proctor would check himself into a treatment facility of literally any type, like he was running away from a reality TV scandal. That was my supposition, is he just gonna bounce and be unavailable because it seemed that he didn't want to go to this deposition. That was my speculation. Gonna be where did Rachel Levis go in Arizona? There, he's gonna go there. And I'm not laughing at treatment. I think it's necessary. It is the timing of the things that are always interesting to me. So, the timing of the things, always curious. So that was the conversation surrounding Docket 112. So now let's go back to what the court said. So the court said, any further attempts to take discovery from the party whose information was the subject of the order of impoundment is precluded. So the court in this order, June 29th, has frozen all further discovery attempts from Proctor. Because we know that that's about Proctor. How do we know it's about Proctor? Because the docket says Docket 112, title, Other Interested Party Michael Proctor's Motion to Impound Affidavits and Supporting Materials. So we know we don't have to be secretive about 112's about, and we watched all the hearings on the June 8th. So they can't take any discovery from Proctor until there's a further order of the court. Your Honor, you came into court the morning of June 8th. Proctor filed at the very last minute on a Friday and said, hey, so my deposition's Monday, but can't do that. Not going to happen. So June 8th, the court has an emergency hearing in the morning. And then is like, well, you've been subpoenaed. And it's pretty untimely to be like, you can't be subpoenaed now. And then the court made them wait all day. The day that was supposed to be his deposition, the court made them wait all day and come back at 4:30 in the afternoon. They came back at 4:30 in the afternoon and the judge said, you need to go get deposed tomorrow. And then all the attorneys went, well, we can't actually do that tomorrow. And then the judge was like, what? What do you mean you can't just go do this deposition tomorrow? And then the judge was mad that everybody wasn't just available for deposition on June 9th. So then it sounds like Proctor's deposition had in fact been rescheduled to last week, because when they were in court on Friday, they had done at least part of a day of Proctor's deposition that week. So they're in court Friday, the 26th. I think maybe it was the 25th, Thursday, that Proctor had gone for deposition, because they said Karen Reed was on Wednesday, the 24th, and it sat for deposition from like 12:30 to 5 p.m. or whatever. And so he had done at least a part day of deposition the 25th. And now on the 29th, the Monday after that hearing on the 26th, the court's coming in and saying, pause. What are you doing? Something he thinks has leaked, because this sentence is like the worst run on ever, but it seems that that's consistent. And then he wanted all the attorneys in person on July 1st. So then a bunch of attorneys filed declarations and stuff on the record. A number of them got filed. It'll be easier to show you the docket. I'm not going to pull all of them up. I want to see the hearing. But I'm sure there's stuff. Is there stuff today? Let's see. There is a note on June 30th that a number of attorneys are excused from having to appear. There are attorneys that are being allowed to appear virtually, including Attorney Little. There are the additional filings by the O'Keefes, and then there are these affidavits, certification of plaintiff and counsel regarding the order relative to order impoundment, and there are a number of those that were filed by everybody. So now I think we're caught up on those documents. We have not gotten through the additional motions to compel. Some of them scanned in like a CAPTCHA and are just a mess, but we haven't gotten to those motions to compel. We are going to go to the hearing from yesterday. It's kind of wild to see the court on, what day was this that he filed this? The 30th? Be like, hey, everybody, be here in 2 days. When he knows there's a number of attorneys that are out of state. I guess the court's just like, whatever, you're going to come in person. It needs to be done in person. I need to look everybody, I need to see the whites of their eyes or whatever. So I guess we're going to go to court from yesterday. Miguelina, will you let the app know that we're going to go to the hearing from yesterday? I know that I got a lot of requests yesterday about it, and I know that we're going to, I know that we've had a lot of requests about it. Thank you, everybody, for the no spoilers, though if there are, you will just find yourself not able to chat. All right. Are we ready? Are we ready to go to court? Let's see what the emergency is. Oh, wait a second. This is what we need. Where is it? I know it's here somewhere. I don't get to use it enough. We don't get to use it enough. We don't get to use it nearly enough. It's appropriate. Emergency. Let's go to court, shall we? Let me pull this up and make sure I have the proper hearing. Wait, where did my document go? I have way too many tabs open. That's my fault. I wanted to make sure we went through the orders that were needed. All right. This hearing, I've got it queued up to a timestamp, which indicates to me that there must be some dead air before this hearing even starts. So I'm going to go back to the beginning of the hearing. It looks like we've got some Zoom room, but I'm going to go back to the beginning and just see what happens as everybody comes into court, and then we'll go from there. Does that sound fair? We'll just Zoom if we have some Zoom room. Let's do that. I need to move myself back to where I was. I Brady Bunch boxed myself. We need to un-Brady box. Brady Bunch box? Yeah, whatever. All right, back to this massive courtroom. I mean, at least the microphones are on, I guess. So there's that. I guess we get lay of the land with the courtroom. It's a pretty big courtroom, all things considered. Some of the other courtrooms I've seen are not so big. So, Karen Reed, her dad, lawyers, people walking in, general ambient noise going on. All right. I'm going to keep zooming as we, let's see. How many attorneys are at the table? We're looking at Karen Reed's counsel table. I recognize a few of those attorneys, but not all of them. And then we have, I recognize Attorney Buck. The female attorney we've seen on Zoom, I do not remember her name, but we have seen her on Zoom. I cannot see the other attorneys beyond Attorney Buck's head. I don't know if there's anybody else at counsel table there, but we've got Seligson, Jackson, Rosenberg, who's talking to the counsel next to him, and then two other attorneys on that side of the table. Rosenberg is, I want to know what Rosenberg's chatting about. Because they're having the best conversation ever. What are they talking about? Jackson does not look like he is having the best time. But Rosenberg is just... what are we talking about? Golf? I'm very curious. Rosenberg is just like, this is what we're chatting about. What? Hello, deputy. I don't understand the... Good... I'm already mad at the camera. I'm already mad at the camera work. All right, the public is coming in. I'm already mad at the extreme close-ups. We have Diller has now appeared. Buck is sitting at the table with an Owala bottle. I like an Owala bottle. Not mad about that. All right. Continuing on. We're going to just zoom. Everybody stop chitty-chattering. It also looks like there is I wonder if this is why the court can't hear the Zoom. Look at the setup. If that is where the court is looking for the Zoom calls, no wonder the court can't hear the Zoom. It's on that screen so far away from where the court is sitting. All right. So far away. I wouldn't be able to hear it either. It's interesting to get the layout of the courtroom because we see the court on Zoom with these books behind him all the time. But it's interesting to get kind of the layout of this, the layout of the courtroom. The clerk seems to be checking in all the attorneys. It's a lot of attorneys. I have told you that I dealt with a multi-defendant litigation. We had 13 or 14 defendants in 2 different court jurisdictions. 11 were in juvie, 3 were in adult, so 14. Maybe 2 were in adult, maybe 3 were in adult. 13 or 14, 11 juveniles, 2 or 3 adults. Nightmare. Scheduling was a nightmare. Finding a courtroom everybody fit in was a nightmare. Absolute nightmare. Absolute nightmare. All right. I'm going to just...
One meeting ID? Yes, sir. Okay.
Great. I'm glad you all have the Zoom call meeting ID. We're going to have to scrub for it instead of zoom. The court coming in. Everybody's like, I'm going to see if I can play some Minesweeper. I'm joking. I'm sure that Attorney Buck is doing something of utmost lawyerly importance and not actually playing Minesweeper. All right. They don't put Minesweeper on most computers anymore. I'm just dating myself.
All right.
This court now in session. Please be seated.
There we
Your Honor, may I
go.
proceed?
Yes.
Wait,
Your Honor,
wrong
for the
one.
record, Civil Action 2483 CB 0692.
Wrong one.
This is Paul O'Keefe, individually and as personal representative of the estate of John Joseph O'Keefe III et al. Versus CNC Hospitality LLC, doing business as CF McCarthy's et al. Your
Not
Honor, with your
Music
permission,
Factory.
at this time, I will call the names of the attorneys in attendance and ask that they state that they are present for the purposes of.
For those of you who are asking, what is Minesweeper? When we are done with this hearing, we will have a conversation about the computer game that was on older computers that is Minesweeper. It was one of those things you could get on just about any computer, work computer, whatever, that killed time, kind of like having solitaire just automatically installed in your computer. Either way, it was an amazing game. It was way, 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 way back in the day. It was so much fun. It was so much fun and real easy to like come back to and put down, and great game. Either way, we'll have a discussion about our dearly departed Minesweeper back in the day. I'm sure you can probably find it online somewhere. But now they're going to do the roll call. I'm curious where all the lawyers are and how many.
The record.
Thank you.
Attorney Brillahante.
Present, Your Honor.
Attorney Horwitz.
Present.
Attorney Fell.
Present.
Attorney Buck.
Present.
Oh, that's where the rest of the lawyers that are normally on Zoom are. They're all in the jury box. Holy shit. So the other attorneys that are there that represent other parties, it seems that most of Karen Reed's attorneys are sitting together. We've got Diller and Buck and the plaintiff's attorneys sitting together. And then it looks like all of the attorneys for the bars, the hospitality, are all sitting in the freaking jury box.
Hante.
Present, Your Honor.
Oh boy.
Attorney Horwitz.
Present.
Attorney Fell.
Present.
Attorney Buck.
Present.
Attorney Diller.
Present.
Attorney Beaton has been excused, Your Honor. Attorney Holstag.
Present.
Attorney Rose.
Present, Your Honor.
Attorney St. George.
Present, Your Honor.
Attorney Donovan.
Present, Your Honor.
Attorney Deely.
Present, Your Honor.
Attorney McCaffrey.
Present, Your Honor.
Attorney Hassett.
Present, Your Honor.
Attorney Maravellis.
Present, Your Honor.
Attorney Shipley has been excused. Attorney Tang.
Present, Your Honor.
Attorney Bell.
Present.
Your Honor, Attorneys Little and Mason are appearing via Zoom.
The angriest roll call ever. The angriest roll call ever. It's so many lawyers.
Attorney Jackson's getting some free publicity as well. For
Attorney Jackson.
What?
Present.
Okay. It's interesting because you can see on the Zoom that the attorneys for Jackson's firm look like they're sitting in the conference room as he's calling Attorney Little. I imagine they're all just sitting in a conference room.
Appearing via Zoom.
Attorney Jackson's getting some free publicity as well. For
Attorney Jackson. Present. Attorney Seligson.
Present.
And Attorney Rosenberg.
Present, Your Honor. You can sit down. Thank you. So thank you, counsel, for being here.
Because you can see the Zoom screen. It looks like the wall of a conference room. Okay. Because Attorney Little was excused to appear on Zoom and not fly to Massachusetts. But the judge making the little jokes after you took a roll call of like 10,000 attorneys sitting in court is interesting.
I scheduled today to be in person because of the significance of what I was advised of last Friday, and because I find the quiet solemnity of the courtroom is a good reminder of the dignity by which courts are supposed to function. One commenter describes how every high-profile case now unfolds in two arenas, one governed by procedure and precedent, and the other by pixels, edits, and algorithms. And how
No, Your Honor. The commentator that matters says that courts now play out in two forms: the court of law and the court of public opinion. But I understand why you took the longer commentary on that, but sure. So they all got called to the principal's office? That's where we're at?
and because I find the quiet solemnity of the courtroom is a good reminder of the dignity by which courts are supposed to function.
Well, subpoenas are supposed to mean something
One
too.
commentator describes how every high-profile case now unfolds in two arenas, one governed by procedure and precedent, and the other by pixels, edits, and algorithms, and how the courtroom has become content and the law has become a spectacle. I recently held a hearing on a non-party motion for a protective order. I required the moving party to provide certain information. Such material was filed together with a motion to impound.
Your Honor, I have a question, Your Honor, because I imagine that at some point you also studied history and history of our laws. I have a quick question, a noodle, really. Can you tell me when the law has not been a spectacle? Like, didn't people used to just get put into the stocks and have like tomatoes thrown at them? And if we go back further, like burned at the stake, public executions, hangings, a fucking coliseum. Like, when can we talk about when the law has never been a spectacle? It's always been a spectacle. How we are determining what happens in our courts has always been a spectacle. Go look at the courtroom that the Reed trial was taking place in originally. It was shaped in a U, with the parties in the middle, the jury on one side, and the public behind and to the side. People make things a spectacle. True. But courts have always been open to the public, should be open to the public, and the public will always give comment. I think that with the advent of the internet, yes, you might have more awareness of what is happening broadly, not just locally, but you don't have as many people storming outside the courtroom trying to get in, which I think is maybe helpful. But the internet has made this a spectacle. We stopped killing people in public. We've evolved some, Your Honor. Dueling's illegal now, though it was still on the books in California for like quite a while as a crime. We've stopped dueling, Your Honor. Humans have tried to evolve into trusting a legal process that does not go to like violence. We're not perfect at it as a species yet, but we try. I hope we keep trying. He's big mad. He's big mad. Okay.
And the other by pixels, edits, and algorithms, and how the courtroom has become...
I'm not done. Emily, are we going to be able to get through this? No. Because you know what? I thought it was a bullshit content creator excuse. I didn't think I was ever going to see the court getting to blame the algorithm. Like, Your Honor. You have become the thing that you apparently despise when you're also blaming the algorithm. This has been happening since before there was an algorithm. But sure, blame the algorithm. Go ahead, blame the algorithm, be mad. It kind of proves the point. Pixels. Pixels. And algorithms. Your Honor, we just want to watch court. We don't want to see people duel or be burned at the stake or like hung in public. But we do want to see how our courtrooms work, and we do want to see that justice is operating justly. All right.
Every high-profile case now unfolds in two arenas, one governed by procedure and precedent, and the other by pixels, edits, and algorithms, and how the courtroom has become content and the law has become a spectacle. I recently held a hearing on a non-party motion for a protective order.
We watched.
I required the moving party to provide certain information. Such material was filed together with a motion to impound.
We saw.
A hearing that included the motion to impound was held on a Monday morning. I allowed the motion to impound during the hearing. The affidavits of the moving party and the attorneys were impounded. Following that morning hearing, I found that there was insufficient information to support a delay in the deposition of the non-party from going forward. However, I further found that given the claims made in the filings, I would delay making a final decision on the motion until later that day.
We watched.
To give the non-party's counsel the opportunity to supplement the record before me.
Right. You gave everybody multiple bites at the apple. It looks like the court wrote out what he wanted to say and is reading it. So, yeah, it was a shit show of a day, Your Honor. It was a total shit show of a day.
I scheduled the matter for further hearing that afternoon at 4:15 with the expectation that there would be additional filings. At 2:22 p.m. that day, the non-party's attorney emailed the clerk of this court and all counsel of record, excepting one, additional materials in support of the motion for a protective order. The filing included a motion to impound additional materials. Exactly 30 minutes after the email to counsel of record of the additional material, which included sensitive and private medical information, similar information to what was in the exhibits to the filing and marked provisionally impounded, was posted to an X account at 2:52 p.m. Upon learning this information, I ordered that the parties and counsel provide a certification.
Well, when did you learn of it? Because we're talking about June 8th. I remember it well. We're talking about June 8th. You're saying that there was a tweet on June 8th after there was an email with information, and then you said you immediately ordered everyone to do this on Friday? So it took, what, 2 weeks?
At 2:52 p.m. Upon learning this information,
I'm backing this up. What?
Included sensitive and private medical information, similar information to what was in the exhibits to the filing and marked provisionally impounded, was posted to an X account at 2:52 p.m. Upon learning this information, I ordered that the parties and counsel provide a certification to the court as to all facts known to them as to any dissemination to anyone other than parties and counsel in this matter of any of the contents of the material impounded on June 8, 2026, and I scheduled this appearance for today. I received certifications from all party and counsel.
Yeah, we saw
32
them.
of them in total. No one apparently has disseminated, nor are they aware of any facts regarding the dissemination of the contents of impounded material to any person or entity other than the parties in counsel in this matter. However, somehow, an ex-account holder, not part of this case, apparently received information that was at least provisionally impounded. Orders of the court.
Did someone... It doesn't sound like someone posted the impounded documents, though.
However, somehow, an ex-account holder, not part of this case, apparently received information that was at least provisionally impounded.
Apparently received information that was provisionally impounded.
Orders of the court have been violated either directly or at the very least in spirit. If these orders are to...
Chat, thank you for not speculating. I appreciate it. Thank you for not speculating. It's just going to derail the entire chat if there is speculation. I would like to hear what the rest of the hearing says. So I appreciate it. But this is going to... Your Honor, what are we doing? Like, what are we doing? There's so much couching language that the court's using. Apparently, it's an odd way to go about it.
Any facts regarding the dissemination of the contents of impounded material to any person or entity.
Yeah, all the lawyers say that they
other
didn't.
than the parties in counsel in this matter. However, somehow, an ex-account holder, not part of this case, apparently received information that was at least provisionally impounded.
Apparently received information.
Orders of the court have been violated either directly or at the very least in spirit.
How?
If these orders are to have any effect, all parties involved must operate with integrity.
What are you even talking about?
Rule 13C of the Uniform Rules of Impoundment Procedure imposes a duty on all persons to protect the confidentiality of impounded material. Additionally, Rule 3.6 of the Rules of Professional Conduct prohibits lawyers from making extrajudicial statements that they know or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding. In case...
Did you tell the lawyers what was said? Because it doesn't seem like you've told the lawyers what was said. Can you just tell them what was said? Like, what are we doing?
Rules of Professional Conduct prohibits lawyers from making extrajudicial statements.
We know that.
That they know or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding.
We know that.
In cases like this, where all parties involved are aware of the public attention, I expect that everyone is taking every precaution to preserve confidential information, to follow the rules of the court, and to adhere to my orders. Because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party. If necessary, I am fully prepared to make such order permanent as permitted by Rules 26 and 30. To any issue counsel may raise as to the management of discovery issues being within my discretion, I invite you to look at the following cases. In the 2000...
Oh, he is so mad. I'm going to back this up. He is so mad because now he's getting on to how the lawyers are dealing with the way that he is handling discovery. But how do you violate a protective order in spirit? You either disseminate information that's impounded or you don't. What is the kind of?
Public communication and will have a substantial
I had to back
likelihood
that
of
up.
materially prejudicing an adjudicative proceeding. In cases like this, where all parties involved are aware of the public attention, I expect that everyone
I
is
backed up
taking
too far, but still.
every precaution to preserve confidential information, to follow the rules of the court, and to adhere to my orders. Because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party.
That's wild.
If necessary, I am fully prepared to make such order permanent as permitted by Rules 26 and 30. To any issue counsel may
wild.
raise as to the management
To any issue counsel may raise as to the management of the discovery issues. I have issues with the management of the discovery issues. Because it's hearing after hearing after hearing, and then it's, we'll put it over, and then it's, subpoenas have to mean something, and then it's, okay, but we're not going to make you do the deposition now. It's just a constant churn of kicking the can down the road. And the court saying one thing in court, and then when we get to holding somebody to it, the court backs down.
of discovery issues being within my discretion, I invite you to look at the following cases. In the 2003 case
You're
of
mad that
Buster
they're
v. George W.
annoyed?
Moore, Inc., 438 Mass. 635.
But of course they're
The
annoyed.
SJC stated at page 653, in general, discovery matters are committed to the sound discretion of the trial judge. In a 2002 appeals court case, Mattoon versus the City of Pittsfield, 56 Mass. Ave. Court 124, the court stated at page 131, trial judges have broad discretion to make discovery and evidentiary rulings conducive to the conduct of a fair and orderly trial. In the 1987 case of Solomon A.
This
versus
discovery's
B.
been
Gruel,
slow as fuck.
399 Mass. 790, the SJC stated at page 799, the conduct and scope of discovery is within the sound discretion of the judge. In Cronin versus Strayer, 392 Mass. 525, a 1984 case, the SJC stated at pages 535 to 536, we remind judges that the scope and timing of discovery is within their discretion, and the prevention of discovery abuse is sufficient justification for the authorization of protective orders. With this authority at hand, judges should not hesitate to exercise appropriate control over the discovery process. And finally, in the 1987 case of Campagna versus the Board of Directors of the Massachusetts Housing Finance Agency, 399 Mass. 492, the SJC stated at page 503 that Rule 37 affords a judge broad discretion to impose whatever sanctions are just in order to ensure that the discovery process operates efficiently.
So you're yelling at them because you don't want anyone to complain about the way that discovery is being handled. Oh, there's another court order that I didn't have context for that we're going to have to pull up. So you're frustrated that the lawyers are frustrated. Of course they're frustrated. He just told the lawyers he's prepared to stay all discovery as to Proctor as a punishment for purported leaking of purported impounded information, where the court has not cited once what the thing is other than it's a supposed tweet on June 8th at 2:52 that he didn't find out about until what? Friday the 26th of June? Okay.
The malicious publication of private information concerning. In order to ensure that the discovery process operates efficiently. The malicious publication of private information concerns me. Whatever opinion that one may have of a non-party, even if warranted, such an opinion does not allow for the disparate treatment of such individual. All people deserve fair and equal treatment in our system of justice, regardless of any personal characteristic, as abhorrent as some of them may be. What I am looking for is for the parties is adequate assurances that their discovery served justice and not any desire to weaponize the rules for pettiness and profit.
Have you been governing over this case yet? I'm going to back that up again. Because he's sure happy with what he wrote.
All people deserve fair and equal treatment in our system of justice.
I agree with that.
Regardless of any personal characteristic, as abhorrent as some of them may be. What I am looking for is for the parties is adequate assurances that their discovery served justice and not any desire to weaponize the rules for pettiness and profit. If the parties and lawyers would enter into an agreement to hold private, personal information in confidence, and if the terms were acceptable to me, I would consider entering it as an order of the court so that any violation would be grounds for a contempt finding and appropriate sanction.
You have let these attorneys on all sides fight with each other, soliloquy, and continue to ramp up because you have not shut it down. We have gotten to, at one point, clickbait lawyering. At one point, we had like a month's long fight over an email that should have just been deleted. And you want the attorneys to trust each other. When you have gamification like the yoinking of a deposition and then the setting of a deposition when somebody else wasn't available, and you have all of these instances of gamesmanship going on, and this is the thing? You want to yell at everybody about something that was posted on Twitter that you say is connected vaguely, and you say that there's been a violation of the spirit of the impoundment order. Okay. And you want everybody to come to some sort of agreement that it would be grounds for sanction. And you're going to think that all of these attorneys are not going to weaponize that against one another? Because we've seen that already. So I'm going to need to see more stuff on this one. All right.
Including dismissal or default. Such an order would need to be more than a stipulation.
I'm going to back that up real quick.
Agreement to hold private, personal information in confidence. And if the terms were acceptable to...
Hey, Your Honor. You should have gotten a discovery referee like a year ago. Maybe that would just solve all of this. Perhaps.
I would consider entering it as an order of the court so that any violation would be grounds for a contempt finding and appropriate sanction, including dismissal or default. Such an order would need to be more than a stipulation that deposition testimony can only be used for the purposes of this case. I encourage the attorneys to confer and to seek to reach an agreement. In the absence of an agreement, I will consider whether to enter an order based on my plenary authority to control, manage, and oversee the conduct of discovery. While you are conferring and seeking to reach an agreement, I will again remind you, as I have quite often, that the discovery clock is ticking. My final request.
No shit, the discovery clock is ticking. But when everything has to be done by motions to compel that take 4 hearings on a motion to compel to actually happen, of course time keeps on slipping into the future. What? You spent an entire day when Proctor was supposed to be in deposition telling Proctor's team to go get more info. And then you said, oh, well, this wasn't good enough. Go to do your deposition tomorrow. And then it ended up being 2 weeks later. Hi, it's me. I'm the problem, it's me. Your Honor, may I just suggest that perhaps when you say things like subpoenas have to mean something, you actually make them mean something. Okay, so he wants the parties to come to a discovery sanction stipulation when these parties clearly don't trust each other. And can you understand why? When one party emails, hey, we're rescheduling the deposition, and the other party is like, oh, the deposition's been canceled. Can you see why the parties don't trust one another? And if there's no trust and you're not holding everybody's words to it, then of course you're going to have these discovery problems. Okay. But what he's saying is he wants the parties to come to an agreement to put higher discovery sanctions on themselves than exist under the law currently, that allow for sanctions including dismissal if there are discovery violations. I'm just going to say, I don't see how that can happen because I don't think there's a lot of trust. I don't think all the attorneys trust one another, and I don't know if the attorneys trust the judge to not spin that on its head. Why would you agree to impose something that doesn't exist under the code? Why would anyone agree to that? Because there are times that we have seen how difficult sanctions like contempt are. Why would you ever agree with the attorneys that the court can go through a shorter process for contempt than what they have to go through? And would you trust this judge to do that? This is just like full on, like being called into the principal's office and scolded. This is wild. But why would anyone agree to what you're asking them to do? The discovery clock is ticking. No shit.
Request to counsel within a... I will consider whether to enter in order based on my plenary authority to control, manage, and oversee the conduct of discovery. While you are conferring and seeking to reach an agreement, I will again remind you, as I have quite often, that the discovery clock is ticking. My final request to counsel with an appearance in this matter is to familiarize yourself with Rule 3.6 of the Rules of Professional Conduct relative to publicity. The rule sets forth a basic general prohibition against a lawyer's making.
This is the second time he said this in this hearing, and he has said this hearing after hearing after hearing. He keeps going back to the attorney rules on publicity. We saw this when he talked about Karen Reed giving an interview that I don't think he even watched. Okay.
Statements.
Clearly, I was wrong when I said it was ridiculous that parties were bringing up publicity in their filings. Clearly, publicity is the thing that gets under this judge's robe because he's brought it up multiple times. He's big mad about it. And other lawyers have thrown it in as allegations against one another. And I've said, this is ridiculous. Why are we doing this? This is why we're doing it. And I can't be mad at the lawyers for that because you play to the audience. I just think it's a bit ridiculous because it's, if we were just moving forward in a normal way, none of this would be happening. We've seen plenty of high profile cases that have been orderly. I mean, sometimes the attorneys go wild, but we've seen high profile cases that have just proceeded in an orderly way.
It's ticking. My final request to counsel with an appearance
That is
in this
wild.
matter is to familiarize yourself with Rule 3.6 of the Rules of Professional Conduct relative to publicity. The rule sets forth a basic general prohibition against a lawyer's making statements that the lawyer knows or should know will have a substantial likelihood on materially prejudicing an adjudicative proceeding. The rule applies.
That's not you. The feed is frozen. That's not you. So.
Applies to lawyers who are or have been involved in the
That's the feed.
investigation or litigation of a case and their associates. As the comment to the rule notes, it is difficult to strike a balance between protecting the right to a fair trial and safeguarding the right of free expression. However, preserving the right to a fair trial for everyone necessarily entails some curtailment of information that may be disseminated prior to trial, especially where trial by jury is involved. If there were no such limits, the result would be the practical nullification of the protective effect of the rules of forensic decorum and the exclusionary rules of evidence.
What are the rules of forensic decorum?
Is involved. If there were no such limits, the result would be the practical nullification of the protective effect of the rules of forensic decorum and the exclusionary rules of evidence. The rule takes into consideration that the public has a legitimate interest in the conduct of judicial proceedings.
Correct.
Particularly in matters of general public concern.
Correct.
However, I'm not so sure that churning the waters to generate social media coverage necessarily can result in a legitimate interest in the conduct of judicial proceedings.
So you're mad? So you're mad? So you're mad? Also, isn't the phrase chumming the water not churning the water? What are we doing? Just tell me you're tired of seeing somebody's face on the internet without telling me you're tired of seeing somebody's face on the internet. Your Honor, whose algorithm is pissing you off? Which algorithm is pissing you off? All right. Churning the waters of speculation. No, I'm sorry. Of social media. We're big mad at social media. I'm sure you were mad at newspapers too.
The rule takes into consideration that the public has a legitimate interest in the conduct of judicial proceedings, particularly in matters
I had to
of
hear it
general
again.
public concern. However, I'm not so sure that churning the waters to generate social media coverage necessarily can result in a legitimate interest in the conduct of judicial proceedings. Read the rule, especially if you have never done so, adhere to it, or be ready to face the consequences for failing to do so. I remind counsel of what one commentator called the quiet expectation of fairness that we have as citizens. Such expectation is based on the framework the founders of our country built 250 years ago and trusted.
That's what it is. He wanted to be in the room where it happened. He wanted to be in the room where it happened, and he wasn't, and now he's mad. I want to be in the room where it happens, room where it happens. Who is the commentator? Was it Aaron Burr, sir? I have questions. Who was the commentator? It wasn't me. This definitely wasn't me. I have some questions, but at least we're back to the founding of our country. I mean, if we're going to go through the entire legacy of law, are we going to go back to the Colosseums, Your Honor? What about the trial of Socrates? Can we get all the way back to there or no? Because that was also a public spectacle. So, how far back are we going? Okay. Quiet expectations of fairness. I agree that there are expectations of fairness. Some of you were saying it was Lafayette. That's funny.
Called the quiet expectation of fairness that we have as citizens. Such expectation is based on the framework the founders of our country built 250 years ago and trusted future generations to maintain. Counsel, do your part to maintain the...
Have you not read the Federalist and Anti-Federalist papers, sir? Let's just take a look back at the founders and the amount of, albeit dated, salacious tea spilling that they did in the papers. All that they did was gossip about each other back and forth to make their point. It is older language, but all it was gossip and accusations and hyperbole and rumors and innuendo. The rumors, the nastiness. Like, it was so much tea. And not the kind in the Boston Harbor. It was so much tea. All they were doing was shit-talking each other in the papers. Constantly. And everybody was riveted. So I love that you're getting back to the principles our founders built this country on 250 years ago was gossiping about one another for their own political gain. But sure. Hey, Griff.
Where is Dad's driver license? He needs it.
Where is Dad's driver's license?
You have it somewhere in this office.
I don't. It's in my wallet and my purse.
Where's your purse?
It's in the mudroom.
Okay.
So from when I took him to the doctor the other day, it's in there. Thank you, Griffin. I love that. I love that the judge is like, the dignity. Okay, look. I agree that there should be some solemnity, but to try to hearken back to the founders and say that there was not a vying for favorable press coverage is just laughable to me. Because it's just not it's not the case. It's just not the case. But okay, Your Honor, sure, go off. Sure, go off. I love the romanticizing.
Your purse is in the mudroom.
It's not?
Yeah.
You'll then look near the table on the bench. It's out there somewhere. It's not here. You can find it, Griffin. It's not a small purse.
What does it look like?
It's the one with the chains.
They all have chains. They all have chains. That doesn't help.
They do not. You'll find it, buddy. I have faith in you.
That's not-
Look with your eyes and your feet. We have now broken the seal on G just interrupting the stream nonstop. He's like, here we go. Nonstop. Speaking of nonstop, this judge wants to harken back to the founders in a very different way. He is reminiscing for a bygone era where the tea was couched in different languaging than it is now. So I told you guys a couple weeks ago, this would go better if Rosenberg started just signing his emails, your obedient servant, A. Rose. I told you it would go better. I said it would go better. There we go. There we go.
Adhere to it, will be ready to face the consequences for failing to do so. I remind counsel of what one commentator called the quiet expectation
I'm sorry, I
of
backed up too
fairness
much.
that we have as citizens. Such expectation is based on the framework the founders of our country built 250 years ago and trusted future generations to maintain. Counsel, do your part to maintain the quiet expectation of fairness. Do not succumb to the attraction of seeking to influence this case through social media. Be what...
Excuse me, Your Honor. Excuse me, Your Honor. You have very much missed the opportunity to say the siren song of celebrity, Your Honor. You have very much missed your opportunity. Do not succumb to the attraction of seeking to influence this case through social media. I don't disagree with that, but I also I don't disagree with him. But it's the filings and the way things are playing out in court is more of what I see as the problem. And if you're not going to tone all that down, and if it works, attorneys aren't going to stop. So if one side says, well, Your Honor, remember, this side's trying the case in the media, and the court's like, oh, yes, they are. They're trying the case in the media, and let's give you more time, and let's do this, and let's not ask any of the questions that we asked last time, and let's just move on. They're going to just keep doing it. So someone has to lead this case. All right. Siren song of celebrity.
Expectation of fairness. Do not succumb to the attraction of seeking to influence this case through social media. Be what a trial lawyer should be, one that tries their case in the courtroom. And remember the provisions of General Laws, Chapter 221, Section 28, relative to the oath of office for an attorney in Massachusetts, which provides, in part, I solemnly swear that I will do no falsehood. I will delay no man for lucre or malice, but I will conduct myself in the office of an attorney within the courts according to the best of my knowledge and discretion, and with all good fidelity, as well to the courts as my clients. So help me God. I wish all of you a happy 4th of July on the anniversary of our America's 250-year-old democracy. May its continue to succeed with all of us working to maintain the rule of law. Thank you.
Court, all rise.
For the record, this matter is continued to July 10th, 2026 at 2 p.m. for hearing on motions to compel in the criminal fourth session.
Court stands
I don't know what lawyer that is who was giving the Jim look to camera. Okay, so we're going to come back to that attorney's look. I just need to summarize real quick. We're going to keep watching because we're going to go back to that attorney and be like, "Welp, let me see if I can summarize this." The judge called 250 lawyers into court with like 48 hours notice. And yes, I was being hyperbolic. It's like 30 something attorneys into court on July 1st with last minute notice to scold them about a supposed leak of former trooper Michael Proctor's sensitive medical information that was filed under seal. And the timeline the court cited in his pre-written monologue that he wanted to deliver to the lawyers and look them all in the face as he said it, in his monologue, was that former trooper Michael Proctor's lawyer sent out an email that had the declaration that we heard the court talk about at 4:15 on June 8th, and the provisional motion to seal and more supporting documentation that when they talked about it, it seemed to be medical records. And that seemed to also be the case today when the court spoke about it. And that was emailed after 2:20 in the afternoon. And then he says that 30 minutes later, there was a post on X. Somebody tweeted a something that seems to be similar information as to what was in the sealed documents. My question is, was that the same speculation that we have been seeing for weeks? Because there was speculation about former trooper Michael Proctor weeks and weeks and weeks before that June 8th hearing. Because even though I don't see even a fraction of what goes on online, I had seen people asking about it in the chat and asking, I heard that Trooper Proctor this, I heard that Trooper Proctor that. And we don't speculate on people's mental health. We do not speculate on unfounded rumors. But even then, there were questions that were coming into chat and coming into our emails weeks before that June 8th hearing. So if all those things are related, and those rumors had been out there for weeks before we even get to this hearing, I don't know what thing the judge is relying on. And I can only hope that the judge gave the attorneys more information than we had. Because if I'm an attorney in this courtroom right now, I'm sitting there going, what the fuck? What was said? What are you referring to? Because lawyers want to deal with information. And if you show me the tweet or whatever the thing is that you think is the problem, then we can go figure out where the fuck it came from. But if nobody sees what the thing is, it just leads to more speculation. I'm concerned that he didn't show the attorneys anything more. I hope that he did. I hope that the court emailed all the attorneys. But when we have seen in other high-profile cases, issues and concerns about sealed documents, issues and concerns about sealed information, issues and concerns about people purporting to be jurors, we have always heard the judge say that they have provided that information to the attorneys and then they put something on the record. If the court was truly worried about information getting out and not just wanting to yell at all the attorneys, I would hope that the way to deal with it would be either to try to get all the attorneys in a room and do it as an in-chambers conference where it's on the record, but it doesn't have to be a public hearing, and say, this is my concern. I need to know how this happened. I need all of you to make sure that you're not sharing anything, that people at your firm don't have access to it. It's summer, that you don't have like a rogue summer intern that's a college student that's like OT. Like, I need you to just make sure that all of this is handled and locked down. We know it's intern season. This is a high profile case. Make sure we don't. But he wanted this to be a public hearing, and he wanted to tell everyone for the 17th time in this case that he doesn't want to see the attorneys making statements to the media at all. There's no gag order in this case. The rules of professional conduct do not say that attorneys can never make a statement, but it's clear that he's put out by it and that he wanted all the attorneys in the room so he could yell at them. So what did the judge say that he was going to do before he read out his scolding and then took off the bench? And then they concluded the hearing with them saying, this hearing's been continued to July 10th. He said that he wants the attorneys to fashion an agreement that seems to go above and beyond the rules currently laid out for discovery, to allow for a variety of discovery sanctions, including contempt, dismissal, and he wants the attorneys to come to an agreement that he would then sign to put a more stringent type of protective order in place in this case that is unknown to us before the law, because the law does have rules about these things already. He was completely vague about what the leaked thing was and why he believes that that could only come from the sealed documents. And he said that if he does not have some assurances that he is inclined to make the order regarding Proctor's deposition permanent. And the order he has right now is that as to Proctor, all discovery is stayed. No further deposition, no further interrogatories, no further investigation. Now, does that completely stay things for Proctor? No, because Proctor is a defendant in the federal lawsuit. Proctor is going to be a necessary witness in the suit against MSP and Canton. So, okay, if you want to stay Proctor's deposition in the wrongful death case, stay Proctor's deposition in the wrongful death case. He's still a defendant in the federal case. All of these things are so interconnected. It's going to be really interesting to see where we go from here, but I don't see how these attorneys can come to any sort of agreement when there doesn't seem to be a lot of trust. There doesn't seem to be trust between the parties, and there doesn't seem to be trust between the parties and the bench. So I'm not sure where they go from here. But the judge is just all up in arms about the pixels and the algorithm and the social media of it all. I'm very curious how all of this came to the court's attention, what came to the court's attention, how it came to the court's attention, and I don't know if we will ever have that information beyond speculation. And I will wait and see if we have any information beyond speculation, but it might take some time. We're going to go look in a minute at another filing by the court that seems to make sense in light of what the court said here, because the court also seems upset at the remarks that keep sliding into the filings. And so if we have time, we're going to go take a look at that. I'm trying to stay on track and not get distracted, but it's hard. Chat. When I said we are going to come back and look at this, I just want to summarize what's happening in court. 9,000 of you went, why aren't we finishing watching this? I said it, dude. I said we were coming back. Breathe, everybody. I said we were coming back. More than once. It's distracting. And then I can't finish summarizing. I said it multiple times. So when the court is talking about the sanctions, because that is one of the things I wanted to finish up before, like I said, we would go back. When we were talking about the sanctions the judge said he was going to put into place here, one of the sanctions he was saying that he wanted to clear a pathway for was contempt. My concern with that is contempt proceedings have a lot of layers of process built in. And it seems that the court is asking the attorneys to fashion an agreement that sidesteps all of the contempt processes and notices. And that is really concerning to me, that the request from the judge is essentially for the lawyers to write out their own punishment so that they can be held in contempt without the procedural, annoyances that you would otherwise have to go to. And he said he would consider sanctions, including dismissal. And I'm curious what the judge means about dismissal. Does he mean dismissing the entire case? Does he mean dismissing the affirmative defenses? What dismissals is he contemplating? And then he also talked about default. What default is he contemplating? Is he contemplating a default like no defenses? Is he contemplating a default for or against a particular party? So when the judge was going through his list of contempt, sanctions, dismissal, default, he did not elaborate on what he's contemplating. But that could be dismissal of the entire case that the O'Keefes brought. That could be dismissal of defenses. I'm really curious what the court is considering. But also, what we've seen from the court is, that he says a lot of things in court and then nothing really happens. So I don't even know. Is this all just bluster? Because so often he comes into court and says things like, a subpoena has to mean something. An attorney's word that they can be there on a date has to mean something. And then he turns around and does something else. I said this discovery was going to be a mess. Welcome to the mess. Here we are. So he pulled in, a fleet of billable hours to scold everybody. I guess we'll see where we go from here. Oh, and to talk about the founding of our country, the solemnity of court. to wish everyone a happy 4th of July, to enjoy the 250th birthday of the Americas, which is what he said, not my words. So, sure. Keep in mind that this judge is also the judge who is in charge of the defamation case with the McCabe's and the Alberts and Higgins versus Karen Reed and Aidan Kearney, and the wrongful death case. He's not yet in charge, and I don't know if it will move. The Reed versus MSP case is in a different jurisdiction, and then Reed sues everybody as in federal court. So he's in charge of 2 of the multiverse of cases. I'm concerned how long all of this is going to take because he seems to have no control of the discovery process at all. And as long as he keeps letting the attorneys quip at each other, none of it's going to change. So, all right. I wanted to summarize. Well, we had a minute to summarize and it was fresh on my mind. Chat, take a breath. So we're going to go back. Replay crew is going to be so confused, especially when we have to. Sorry, replay crew. I know chat was anxious to get back to the hearing while I wanted to summarize. So I apologize, replay crew. And if replay crew, you can't see the chat because we had technical difficulties at the beginning, it's going to make it even harder. So replay crew, my deepest apologies. My summary on all of this is the judge wants to be in the room where it happened. But some days when you have, 16,000 people ignoring what you just said and then being like, but wait, it's distracting. All right. Let's get back to court because they panned to all the lawyers sitting in the jury box. And one of the lawyers was just like, well, that was great. I can't imagine how pissed the lawyers would be in court if they don't have any further information. Because if you are just sitting there getting the onslaught of the court's diatribe, I don't understand how the lawyers are supposed to know even what happened. But
26 at 2 p.m.
As they pan away, for those of you listening in the background, come on back. As they pan away, there is a lawyer sitting in the jury box because it's completely full. And the face is just like, whoop. It's so funny. It's so funny.
Hearing on motions to compel the criminal fourth
Look at
session.
Court stands in recess.
Yes, counsel. That expression.
There's no opportunity to be heard? There's obviously no opportunity to be heard.
I was unaware. I'm just covering for Clerk Donovan today.
Yeah, no. There's no opportunity to be heard. The judge walked off the bench. Look at the end of this hearing. The judge walked off the bench and they called the session to a close.
May it continue to succeed.
We're gonna go back to the very end. They called court to a close. The case is off the record. There's no opportunity to be heard. No, the court doesn't want to hear from anybody.
With all of us working to maintain the rule of law.
So this is the very end.
Court, all right.
For the record, this matter is continued to July 10th, 2026 at 2 p.m. for hearing on motions to compel the criminal fourth.
Yeah, that's calling the court off the record. So they are continuing it to the next date. The court was up and off the bench, and then the clerk is calling the next date while the court is walking back into chambers. But that's it. Done.
Session.
That's all.
Court stands in recess.
There's no.
When they say court stands in recess, the case is no longer on the record. The case has been continued. The hearing is done. This is it.
Opportunity to be heard? There obviously no opportunity to be heard.
I was unaware. I'm just covering for Clerk Donovan today.
Is there an opportunity before everybody departs to let the judge know that we would like to be heard?
I absolutely.
Is there an opportunity to be heard? Nope. Is there an opportunity to be heard? Nope. It seems like both sides wanted to be heard to me. But no. I'm sure all the attorneys would like to be heard. I'm sure all the attorneys have questions. But no, there's no opportunity to be heard. That's the end of the hearing.
Compel
We'll watch it one more time. And then it immediately goes, beep. That's funny.
criminal fourth session.
Yeah. No.
Court stands in recess.
There's no opportunity to be heard? There obviously no.
That's two different attorneys. I think the first one might be Seligson, but that's two different attorneys. Somebody speaks before Jackson does and says, I think it's Seligson, and says, so there's no opportunities to be heard. But that's two different attorneys speaking.
No opportunity to be heard.
I was unaware. I'm just covering for Clerk Donovan today.
This clerk covers a lot, though, because we've seen him in court quite a bit.
Is there an opportunity before everybody departs to let the judge know that we would like to be heard?
I absolutely.
The clerk says, I absolutely. I mean, they can check with the judge. We're back in court. The screen is completely black. No, if the judge wanted to hear from anybody, he would have given them an opportunity to be heard. Yeah, the court isn't giving anyone an opportunity to be heard. It looks like the clerk is coming back out of chambers. Sorry, we went to tone again, but no opportunity to be heard. That's that. No opportunity to be heard. I'm sure the clerk went back and said to the judge, because he said, can we go ask the clerk? The clerk probably went and asked and said no. If the judge wanted them to have an opportunity to be heard, the judge would have given them opportunity to be heard. The judge wanted them to come into court so he could look all of them in the eye, tell them what he wanted to tell them, and then walk off the bench and have the hearing continued. There is nothing they can file to respond because remember, the court already scolded them for that. We covered that filing. The court already said, don't just file things to the docket. The court already said it. But the court also filed this really interesting request. Let me go find it because we're going to pull up these motions later. But it was part of the Tully motions. A lot of you are like, what a waste of time. Could it have been an email? He didn't want it to be an email. He wanted to look at everybody in the face and yell at them. He didn't want it to be an email. The thing that I would find most concerning is that if the attorneys don't know what the thing is that prompted this, obviously they know what the court thinks the thing is. But if they don't have what the court is looking at, an email, the tweet, if they don't have that information, the attorneys can't really do much with that other than the court's mad about something and we don't know. But it was something. Also, when I said that the filing system, I just want to share. When I said that the filing system was having some issues, this is what I mean. This is what I mean by the filing system having some issues. Because what in the gobbledygook CAPTCHA is this? It's formatted like a pleading, but it did not scan properly at all. So when I said some of the filings haven't scanned properly, that's what I mean. It is just mangled. And that has happened in two things that I have pulled up from this court. And I was going to go over this hearing, or I was going to go over this filing when we went to the filing with regard to Tully. But after what the court said in this hearing, this popped into my mind because I was putting these in order last night. We are going to take a look at something the court filed on June 26th. We're not going to look at the entire Tully filings because I have a hard stop today, but we have this odd request from the court that we're going to cover more when we get through the Tully filings. Tully is saying that he's filed a motion to quash the deposition subpoena, saying I'm not coming to the deposition. So Tully filed the motion to quash. Reed filed the opposition. Tully filed a reply. And in that filing sequence, after it was filed, the judge filed this. And so the judge filed on June 26th, the same day as the other order. Order requesting information from Defendant Reed relative to opposition to motion to quash filed by non-party Tully. On or before 12 noon, Monday, June 29th, Defendant Reed is requested to provide a factual basis for the following statements in her opposition. Quote, buoyed by the treatment that other subpoenaed witnesses are getting by resisting their depositions, and, quote, the manner in which other subpoenaed parties have been handled in this case. So when the court was going off about, by the power of Grayskull, I have the discovery, and was talking about his inherent power to manage discovery and the parties' comments or concerns about his handling of discovery, I think it goes back to this. And we have not gone through those motions yet, but the court was citing case law about I'm the king of discovery. And it seems that these types of comments are part of what he had in mind. However, I can understand if Reed's team is saying, well, Your Honor, the fact that both Michael Proctor and Colin Albert have gotten what they've wanted, are you surprised that there's now a flood of other deponents saying that they don't want to be deposed? Because they are now seeing how that's going and saying, well, if it's working, we keep trying. Because what did Proctor accomplish? He wanted more time for his deposition, and he got it. He got an extra, 2 weeks? And then he only did 4 hours of deposition? 4.5? What did Colin Albert want? To not come to his deposition. By Karen Reed's team. He went to the deposition by the O'Keefes. And what has happened so far? Well, so far, he hasn't had to come to deposition. So the court was just like, what do you mean? And I think that this is where the court was also clapping back today, saying, or in the hearing from July 1st, saying, I'm the one, I'm in charge now, Phasma. I'm the one in charge of discovery. Okay, Your Honor. He's so mad. So, we will look at the Tully filings on a different day. We do not have time to do that today. But what do we have now? We have the judge clapping back at the attorneys leveraging what the court is saying against one another, to the point where I'm like, why are you bringing this up in a filing? Oh, because it actually will work with this judge. That's why you're bringing it up. The judge upset about social media, or the perception that lawyers are trying to gamify social media to their advantage. The fact that discovery is not moving along more quickly, but now you have Colin Albert not being deposed until there's more information, Proctor not being deposed or turning over discovery until the court gives everybody the A-OK go ahead. Both Alberts, both McCabe's and Higgins moving to delay their depositions to the point that there's another motion to compel, and Tully trying to quash the subpoena so he doesn't have to come to a deposition either. So you got like 7 people who are just like, nah, deposition, not for me. Your Honor, if they keep getting the delay that they want, you are going to keep having all of the fighting. So, at some point, subpoenas have to mean something, and a lawyer's word has to mean something. But I can see why none of these lawyers trust one another, given the representations and the way everything is fought over. Well, Your Honor, they canceled the deposition. Your Honor, we continued the deposition. You saw a whole email thread of them fighting over continued versus canceled. Of course, there's no trust there. And the court isn't fostering that either. So, we've got a few questions to answer, and then EDB has to go. It seems that Griffin found what he was looking for, and that was great. At some point, the court needs to just hold them to their deposition dates. And then he's going to be so pissed when we get to August and everybody's like, but the depositions aren't done. And then he's going to get even more pissed when the fingers start pointing back at him. Why isn't this deposition done? Well, Your Honor, we brought a motion to compel. And then we had a hearing. And then we had another hearing. And then we needed another hearing. They're going to have 3 or 4 hearings on just Colin Albert. So yeah, it feels like the wheels have come off. And Phoenix says, this is so frustrating. Is there a legal process for switching judges? Not at this point. Not at this point. This has become a mess. We said that this was going to become a mess because the court is a lot of bark when they're in court, but then doesn't actually follow up and make anybody do anything. So that's what's happening. And it's wild. But the court being mad about social media is also kind of hilarious to me because, well, I don't know what the court's looking at because the court didn't say what they were looking at. When the courts have had concerns in other cases, it either has been in-camera hearings or the court has like shown the thing. So I don't know what the thing is that the court's mad about until we see it from the court. I know there's tons of speculation. I can see it in the chat. But us guessing at what the court's looking at isn't helpful to me. I want to know what the court is basing this monologue off of. And I hope that maybe at some point we see it. We can all try to guess, but I want to know what the court is basing this off of. Because we've seen how these things can be skewed. We saw it in Depp Heard. We see how these things can just spin out really quickly. Did the court see a tweet? Or did the court get information a la Courthouse Becky? Did the court get information of somebody telling the court that there was supposedly a thing that he didn't see? Like Courthouse Becky saying, oh, but there was a Facebook post. Oh, but it's gone now. Oh, but it kind of said this. So do we have a Courthouse Becky situation where it's a game of telephone of, oh, but there was a Facebook post and it was this and this? Or did the court actually see the thing? And was it a thing that was still on a social media platform, or was it a screenshot of a thing? Was it something that was manipulated, or was it something that was genuine? How did it come to the court's attention? Did one of the attorneys bring it to the court's attention? Did a member of the public bring it to the court's attention? I have so many more questions for this. And so I'm not going to speculate about what the court's basing their information off of because we've seen how wildly that can go in a variety of cases. So until we know what the court is actually looking at, or if the court was being told something through a third party, you guys raise a great point. What time zone is the purported timestamp from? If it's an authentic image. If the court even saw an image. Because I don't know if the court ever saw a post on Twitter or if the court was told about a post on Twitter. I don't know. So I've got a lot of questions. And we'll see. Because who knows? But we've seen enough happen that I would like to wait to see what the court has to say. And wild. Brentwood Chick said, thank you for the 20 gifted memberships. Thank you to everyone who gifted memberships. I'm going to try to get to, I am at my overtime for needing to go. So I'm not going to get to all of the questions. Apologies, chat. I got very long-winded talking about the court thinking that the founding fathers weren't all talking mad shit about each other in the papers. I take issue with pretending that they weren't talking shit endlessly because it was one of my favorite parts about reading the Federalist and Anti-Federalist papers was that they were all just shit talking each other. It's like so much trash talking. It was they dueled a lot. They were all very offended with one another and the things that were being said. And I feel like the court's skipping over that part, that all of it played out as publicly as it could play out. The trials played out as publicly as they could play out. It's just so funny that he's just like, meh. It's just so funny. All right. Don't tell him about the Thomas Paine papers, right? Right? It's just wild to me that the court wanted to call everyone into the principal's office and scold them. He's like, I can't tell you how I feel until you're in the solemnity of the courtroom and I can sit up on my bench and tell all of you to go reread the rules of professional conduct, which he has cited in multiple written orders. This judge. I'm so frustrated. I'm so frustrated with all of this. But what are we going to do? I guess we're just going to watch it play out in court. And we're going to watch it play out in court. We're going to cover the rest of the filings next week. We're going to have a new podcast for you on Monday. We're going to be streaming next week. Hopefully Dr. B is feeling fantastic and everything's easier, but we'll see. Just Laura said, will we learn who was in the ex parte communication? The lawyers should. I don't know if the public will. I'm concerned that the lawyers haven't. But the lawyers should. And I hope that they do. I don't know if the lawyers know. Let's see. Lola said, Judge, not a spectacle. It's just called transparency. I mean, this was a little bit of both, wasn't it? But it's because the judge was being so dramatic about it. Just, if you're not so dramatic, Your Honor, it's not dramatic. We have watched some very boring and dry court days. So with that, law nerds, we have stuff to cover in the Corey Richins case. We have stuff to cover in the Bricks and Minifigs case. We have much to cover in this case and others. Y'all are the best, law nerds. Thank you. I know today was hard with no spoilers. I appreciate you. I will see you back here after 4th of July. Take care of yourselves. Take care of each other. Have a safe and happy 4th of July. And I hope to see how no Scotland, no party converges with the 4th of July. I'm ready for the World Cup 4th of July convergence because I think it's going to be a delight. I'm very much optimistic about being delighted. So that I hope that you guys have a good 4th. Take care. I will see you soon. I will keep you posted in the app. Have a great weekend. You guys are the best. Law Nerds, thank you. Thank you for being here. Thank you for being a Law Nerd. Thank you for being patient. We'll always get there. And I'll see you soon. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop because you never know when something's going to pop off. Thanks for being here and thanks for being a Law Nerd.